Dear clients, dear friends, dear colleagues, today we have Janat Nurmagomedov with us.
Hello.
Janat is a partner of Volatov & Partner, also specialized law firm for trademark registration, but also a specialist for any violation of the trademarks. And today we would like to discuss any or some consequences which are corresponding to any violation of the trademarks on the territory of Kazakhstan. And Janat, I think we can start with some cases which you have in your practice. So the floor is yours, feel free.
Thank you, Michael. Dear clients, dear friends, hello again. My name is Janat Nurmagomedov, and yes, we will talk today about liability for the trademark infringement and the ways how to enforce the trademark rights. Well, first of all, I would like to say there are four main ways of enforcing the trademark rights. The basic way is to try to come to an agreement with the infringer in a pre-court procedure by sending the cease and desist letters, by having negotiations, meetings, trying to get the contacts with the infringer. In this case, the trademark owner is able to request anything from the infringer, and one of such requests could be to pass the infringing goods, the counterfeit goods, or sometimes it could be genuine goods, to the possession of the trademark owner for further destruction, for any further function. The second way to enforce is to file an application to the Justice Department. In that case, there would be started an administrative case, and the justice officers would conduct a raid action against the infringer. There should be complied several requirements according to the law. The requirement to confirm that the infringement takes place, the requirement to confirm the existence of the infringer, his place, and so on. So we have to provide some kind of pre-functional evidences to start an administrative case. However, the consequence of the result of the administrative case would be here a court decision, according to which the court would fine the infringer for something around $300 or maybe we could say about 280 euro, and confiscation and further destruction of the goods. The counterfeit goods will be destroyed. The genuine goods, if it is the parallel import case, they will be confiscated to the possession of the government. In this case, we cannot come to any amicable settlement. We cannot come to taking the goods from the infringer and bringing them to the trademark owner. So the only result would be fine and confiscation, plus or without plus destruction of the goods. The third way is the criminal case, the criminal raid action. In that case, we would have to file an application to the Department of Economic Investigation. In the past, we called this state authority law enforcing agency, if you want to. We called them financial police. Now we call them Department of Economic Investigations. This Department of Economic Investigations, they also conduct raid action with minimum information about infringer, with minimum information about infringing products, but we at least should give them the idea where to find that infringer, the address, the contact details, and so on. And the criminal case may be started only if the harm caused to the trademark owner exceeds 13,000 euro or $30,500 US, around that.
Mm-hmm.
Well, in that case, the criminal case would be started. The goods will be also arrested from the infringer, and there would be started a pre-court investigation which may last up to 2 months. During these 2 months, or if the case is passed to the court, the trademark owner would have the ability to come to amicable settlement with the infringer. And in that case, one of the requests from the trademark owner could be to pass the infringing goods, either genuine or counterfeit again, to the possession of the trademark owner. Well, if the amicable settlement doesn't happen, the infringer might be again fined up to the same 500 or 600 US dollars, or about 850 or 500 euros, and the goods will be destroyed by the government. However, in case of amicable settlement, we have the potential ability to obtain the goods and pass them to the trademark owner. The final fourth way to enforce the trademark rights would be to file a lawsuit to the civil court. Well, the civil court cases, they are rather long. They last starting from 2 months, and they might last for up to 2 years or even longer sometimes. And at any stage of civil case, the trademark owner may also come to amicable settlement with the infringer. And again, the trademark owner in that case might request number of things: to pay compensation, to stop the infringement, to destroy something and something. And in some cases, the trademark owner might also request to pass the goods from the infringer to the trademark owner. Well, as I said, we have 4 main ways how to enforce. In 2 of them, in administrative and in criminal, we can receive the fine over the infringer, and we can receive the confiscation and destruction of the goods. In criminal case, we may request passing the goods to the trademark owner. In civil case, we may request that, and in pre-court case, we can also request that thing. So the reason of why we are doing our meeting today is that we wanted to observe this situation when the goods are coming to the possession of the trademark owner, and what the trademark owner may do with these goods after he received these goods. Well, first of all, he might send them to the destruction by himself, or secondly, he might try to give them for some social needs, or might try to repack them and to sell finally. In all those cases, there arises an issue of paying the taxes, of putting the goods on the balance, and this is what Michael will explain from now.
Yes, Jonat, thanks a lot for the overview, for a really detailed overview how the trademark owner can, let's say, fight, and what kind of rights he can claim within the described scenarios by you. Let us have a deeper view on the consequences after the court decision or after the criminal investigation, etc. I may underline first of all one thing, and based on our experience, it's already possible if you file a criminal case, if there is also a court session, as far as all the requirements are fulfilled. So theoretically, it's also possible to claim for potential damages by the trademark owner.
Exactly.
So there's the question how to calculate the damages which may arise. So it makes sense to apply for it already, from my opinion, already during the process, in order to have a clear statement by the court that a kind of damage is arised in the amount X. There is also the question, what happens with the goods? If the goods will handed over to the trademark owner. It's always a question how to treat them in the balance sheet, how to treat them from the tax perspective. I mean, any valuable goods, any goods which has a value, or leads to an increasement of a property on the side of the trademark owner. Here it's the first question that already during the processes we strongly recommend to determine the value of such goods. It could be the value only of some material goods, of the raw materials. It could be a different method which an expert could choose for such purposes. So, why it's necessary, why it's needed? It's needed to avoid in the future any discussion with the tax authorities and to explain that it was some contrafacts which has been handed over to explain why this contrafacts does not have the same value as a original trade goods. And we recommend first of all that to determine the value of such goods within the court decision or within any mutual settlement, mutual agreement with the party who is violating the trademarks. That may be for first of all, so far. Secondly, if we are looking on the consequences side, so we have also to differentiate. It could be the case that some goods handed over in order for any review, for any, I don't know, any other procedures, but in fact the goods could be destroyed after the trademark owner has reviewed them somehow. That's of course the question that the trademark owner needs to have a documentation that he has destroyed the goods, for example, and also the reason why he is destroying goods. So all these facts shall be mentioned in the court decision. It should be, for example, mentioned that of course that the trademark owner will take 2, 3, 4 months to see what kind of contrafacts is here in place, where the contrafacts maybe have been produced in order to avoid any violation somewhere abroad. But it also shall be stated that the costs for destroying of such contrafacts shall be borne by the other party. And here it's important, if the trademark owner took it under our costs, that also these consequences of tax payments could be determined as a part of the damages caused by them. So that's as an idea how we would like to proceed. I mean, there is a huge frames how to deal with the party who is violating, and of course then the definition of the damages, which shall be explained to the court. Another approach could be if you have really maybe goods which are originals but which has been brought from abroad in violation of any license agreements. It could be parallel or grey import, for example. We have also a lot of cases in respect of Turkey, in respect of China, for that. And if the trademark owner has the goal to hand over all the goods to some social needs, for example, so maybe it makes sense to stipulate it clearly in a settlement agreement or in a court decision that the handover will take place directly from the party who is violating in favor of the of any party who needs these goods, for example, just to avoid these transactions between the violating party and the trademark owner, and then from the trademark owner to another party, just to avoid this discussion, to avoid the record of any valuable goods on your own balance sheet. So far, Jonathan?
Yes, thank you, Michael. That's quite motivating, I would say, and I am sure that we have a lot of things to discuss with clients in all these scenarios, and there is much more to say about all these types of enforcement, and I think that personal meetings and overview of concrete exact cases would give a better idea.
We are looking forward to cooperate, also in order to save time, to save also additional resources for our clients. As I mentioned, based on my experience, we have had such issues also in Germany, and the German criminal law also allows to save some efforts, to have the conclusions by the court in respect of the damages, in respect of the responsibilities, who has to destroy the goods, and at which cost this destroying shall take place.
Okay.
So,
thank you for saving your time to listen to us today. We hope to be very helpful to you. Thank you very much and have a good day.
Thanks a lot. We see us next time at the next podcast. Bye bye.
Bye bye.